70 of the House of Commons Standing Committee on Justice and Human Rights, pursuant to House Order adopted on March 22nd, 2023. The committee is meeting in public to begin its study of Bill S-224, an act to amend the Criminal Code, trafficking in persons. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating via video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. For members in the Zoom, in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regards. So welcome, everyone. We are studying Bill S-224, an act to amend the Criminal Code, trafficking in persons. To help us with the study, we have today Dr. Janine Benedet, Queen's Counsel, Professor of Law from the Peter Allard School of Law at UBC. We also have from Brave Education Foundation, Holly Wood, researcher and educator, also via video conference. And from the Canadian Alliance for Sex Work Law Reform, Sandra Kahun Chu. I hope I get that right. I don't see you on screen. Oh, there you are. Thank you. And I apologize. I think we had to cancel you last time. So thank you for rescheduling and coming back. Things in Parliament happen that we have to readjust from time to time. But thanks for being here. You'll each have 5 minutes to deliver opening remarks. And then we will have questions coming from the members, and hopefully anything that you might have left out you can answer within that time. So we'll begin with Dr. Benedet, please, for 5 minutes.
Thank you, Mr. Chair, and thank you to the committee for the invitation to speak on this important bill. I'm a law professor and lawyer in Vancouver and have developed expertise on the criminal law in this and related areas of sexual violence and exploitation, over 25 years of researching, teaching, and representing clients in court. In my introductory remarks, I'll offer 4 observations, 2 general and 2 specific to the bill. I know that time is tight, and so I will try to be clear and concise. First, human trafficking is a serious global problem and a serious problem in Canada. It is a practice that preys on the vulnerable for profit. Thomson Reuters recently did an investigation that found 700 establishments across Canada involved in sex trafficking, many with connections to known criminals. And they estimated that the illicit profits in Canada and the United States combined are $2.5 billion annually. Most sex trafficking victims in Canada are Canadians, and this is a practice that disproportionately targets Indigenous women and girls, those with intellectual disabilities, and other vulnerable groups. Canada has made an international commitment to fight human trafficking, and we cannot afford to be complacent or in denial. Human trafficking is not a moral panic, and it is not a sleight of hand. Second, the distinction between sex trafficking and the prostitution industry as a whole, legally speaking, continues to be misunderstood. Not all prostitution is sex trafficking. Legally, the difference between sex trafficking and prostitution, even when that is relabeled sex work, is not that one is forced and one is free. That is a common misconception. The difference is that trafficking requires a third party, a trafficker. You cannot traffic yourself. Where there is no third party, there is no trafficking, but there can still be exploitation. To use a simple example, a guy who buys a 14-year-old kid who's run away from home and trades him sex for drugs is exploiting that kid. But if there is no third party involved, no pimp, that is not trafficking in a legal sense. So the contentious question of whether all prostitution is exploitative and discriminatory is not what is before the committee today. And of course, trafficking laws apply to traffickers, not purchasers who drive the demand for trafficking. Canada has an international obligation to target the demand for sex that fuels trafficking, but we have separate offenses for buyers of sex, which are also not before the committee today. Third, and turning to the bill itself, the definition of trafficking in the criminal code at present is unnecessarily convoluted and too restrictive. It is very hard for victims to come forward, and having an offense that is so difficult to prove makes matters worse. Only 12% of trafficking charges that go to court result in a conviction for a trafficking offense. So removing the requirement to prove reasonable fear for safety, as this bill does, would be very helpful, because it is inappropriate to impose a reasonableness requirement on victims. We should be focusing on the actions of the trafficker. And fear for safety is not the only way that traffickers influence and control their victims. A trafficker who controls access to drugs, or who threatens to disclose pornographic photographs to a woman's family, or who threatens to report her welfare fraud, may be very effective at causing her to remain in prostitution. So this requirement of fear for safety is too restrictive and unhelpful. And I'll just say that we've rejected a similar requirement in the law of sexual assault, and the only offense left in the criminal code with a similar requirement is stalking, criminal harassment, and that requirement has been consistently criticized. And then fourth and finally, while I support this change, I would like to see it go further. The definition of exploitation in the bill is limited to causing someone to enter or remain in, and I'm talking here about sex trafficking, the sex trade, through coercion, deception, abusing a position of trust, power, or authority, or any other similar act. This is still quite narrow, depending on how the courts interpret it, and fails to capture a number of ways that traffickers groom and manipulate their targets, and select those targets based on their vulnerability. The Palermo Protocol includes the exploitation of a condition of vulnerability in its definition of exploitation, and I would like to see the Canadian Criminal Code definition brought into line with our international commitments and that internationally accepted definition. So thank you for your time, and I welcome your questions.
Thank you, Dr. Benedict. Next, we'll go to Holly Wood from Brave, please.
Hi there, my name is Holly Wood, and I'm representing Brave Education for Trafficking Prevention. I'm a Master of Legal Studies student at Carleton University, currently finishing my thesis focused on police responses to sex trafficking and sex work in Ontario. I hold a Bachelor of Arts Honors in Law from Carleton. I'm a nationally licensed human trafficking prevention educator with Brave Education, where I assist with building and delivering sexual exploitation prevention curriculums for grades K to 12 and adults. I serve as the Vice Chair of the Ottawa Coalition to End Human Trafficking and the Chair of the Advocacy Committee. I've worked for the Ontario Ministry of Children, Community and Social Services with foster care youth who are at risk of or actively being trafficked. I've worked at the Elizabeth Fry Society of Ottawa with women who were criminalized as a result of being trafficked. And I have worked in criminal defense, where the firm I worked for successfully defended a human trafficker. For my first example in support of Bill S224, I looked to the experience of a survivor who Brave has worked with. Out of respect, I will speak of this survivor anonymously. As a young 19-year-old girl, she was trafficked by a man whom she loved and whom she thought was her boyfriend. She had a relationship with her trafficker. He trafficked her in 5 cities across Canada. After years of being trafficked, she learned what trafficking was. She learned that she had, in fact, been trafficked. She pursued legal action against her trafficker. When asked to attend court to provide a victim impact statement, she got on the stand in the courtroom in front of her trafficker. She looked out in the courtroom and locked eyes with him. She immediately felt feelings of love and dependence flood her body. She ran out of the courtroom and did not testify because, regardless of the fact that she knew she had been trafficked, she was so in love with him that seeing him in that courtroom triggered an emotional response of love, not fear. She was not afraid of her trafficker. She was in love with him. To this day, she tells us that she would go back to her trafficker in an instant because he made her feel more loved than her family and friends. She is a prime example of why this bill is so important, because even when victims of trafficking know they have been trafficked, the feelings of love and attraction to their traffickers do not disappear. Effects of the manipulation, coercion, love bombing, etc., do not end just because a survivor has been pulled out of their situation. Hence, it is important more now than ever to remove the requirement to prove fear so that survivors of human trafficking can pursue justice without the unfair burden of proving fear and without having to worry about the years of an emotional relationship with their trafficker getting in the way of securing a conviction for the crime they endured. Human trafficking and exploitation can affect anyone, not just women and girls. For my final example, I will look into my colleague, Ana Lucia Mariaca Pacheco's published research on male exploitation and familial trafficking. According to Ana Lucia's research, there can be several reasons why men or boys may be hesitant to show fear after being trafficked or exploited. Societal expectations in Canada place emphasis on men being strong and tough and suppressing their emotions. Therefore, many men and boys may feel pressure to not show that fear or weakness. They may believe that expressing fear or vulnerability is not productive or helpful, and may choose to internalize their emotions to maintain a sense of control or to try to forget about their trauma. Male victims may experience feelings of shame or embarrassment, judgment, or stigmatization if they show that they are fearful or unable to protect themselves from their male or female perpetrator. Therefore, by taking out fear and showing male victims that it is okay to finally speak out about their exploitation, hopefully we will see an increase in disclosures and convictions. It is important to approach this bill with empathy and understanding, recognizing that in any response to trauma, you are shaped by a complex interplay of personal, cultural, and societal factors. Fear can look like different things to different people, and in many cases is not what the current provision deems fear at all. I thank the committee, MP Colin Carey, and all other parliamentary bodies for paying long overdue attention to the devastating crime of human trafficking. Bill S224 is one of many steps we must take to protect our communities, and most importantly, those affected by the crime of trafficking. The fact of the matter is, our current laws in Canada are not evolving at the same pace as the crime of human trafficking. And in the anti-human trafficking movement, we have a common saying: it is a legal system, not a justice system. For myself and my team at Brave, Bill S224 can change the narrative for our legal system and can make justice more accessible for victims of human trafficking. Most importantly, Bill S224 will reinforce that the trafficking of individuals in Canada is not acceptable, will not be tolerated, and will be punished accordingly, in line with the rights and dignities of victims who, with the help of Bill S224, will feel more inclined to stand up to their traffickers in a courtroom in order to protect current and future generations. Thank you.
Thank you, Ms. Wood. We'll now go to Sandra Kahonchu from the Canadian Alliance for Sex Work Law Reform.
Thank you, Chair. I'm sharing my time with Elaine Lam, who will go first. Thank you.
Sure.
Hi, good afternoon. I am Elaine Lam, Executive Director of Butterfly. We work with over 5,000 migrant sex workers in Canada. I am shocked that committee did not consult any migrant rights, racial justice, and sex workers who are directly impacted. Many scholars, violence against women, racial justice, and human rights organizations already show their opposition of this bill and show the concern that they are not having opportunity to tell you how this bill is harmful. The claim is that the bill will help charge traffickers and bring them to justice. It will not. As Sandra will explain, this bill will lead to more human trafficking charges laid against migrants, Black racialized people, and sex workers, and those who are providing support service to others, and take away their livelihood, make them live in fear, drive them work even more underground. As the concern expressed by some of the committee members already, this bill do not differentiate sex work and human trafficking. It cannot differentiate whether people ask other person to organize the work or they are being forced or exploited. Both of them will be charged as trafficking no matter the nature of the relationship. It is wrong to assume all the third party are exploitation and human trafficking. Poor racialized migrant sex workers rely on community support to stay safe. They help each other to access transportation, food, medical care, translation, safe work environment. If Bill 224 pass, anyone help sex workers stay safe, particularly Black and migrant, will be charged as human trafficker. People are too afraid to associate with sex work, and that will make sex workers be more isolated and vulnerable. Advocates against sex work have long used anti-human trafficking campaign and policy to further their racist anti-migrant agenda. They promote moral panic, racial discrimination, and hate against sex industry. By calling for the criminalization of sex work and increased policing, the goal of anti-trafficking campaign often is not ending trafficking, but is ending sex industry. They do not protect sex workers, but ending sex work. You are all here today because you care about the rights and safety of vulnerable people. You should listen to the community. And many racialized Black migrant sex workers tell you, don't take away my agency. We cannot let Bill 224 pass. Bill 224 do not protect us, but put us into dangers. I give Sandra more to explain more. Thank you.
Thank you, Elaine. My name is Sandra Cajon Chu. I'm the co-executive director of the HIV Legal Network. I have two main points to add about Bill S224. First, the removal of the threat to safety requirement will capture cases where no exploitation exists. Proponents of this bill describe difficulties obtaining direct evidence from a potential complainant. But the test today is already an objective one and does not require complainant's testimony. Removing this requirement merely gives more power to police and prosecutors to define, and often wrongly define, violence and exploitation for communities. In the case of sex work, violence and exploitation is assumed. For example, Professor Roots has documented how police pressure sex workers to take on the trafficking victim label, despite the rejection of this label. Without the threat to safety requirement, determinations of coercion or exploitation are made through biased perspectives of sex work. Second, as Elaine described, the amendments risk capturing all third parties in sex work, including those who provide supportive services to sex workers. Butterfly and the HI Legal Network have been consistently told by law enforcement that any third-party involvement with sex workers suggests exploitation that warrants investigation. But research has documented how police and prosecutors insist that pimping is a major problem, focusing their attention on young, poor racialized men, and particularly Black men, despite sex workers' more nuanced accounts of third parties as protectors and intimate partners. As Elaine mentioned, many sex workers also take on third-party roles, and migrant, Asian, and other racialized communities rely on family members and community for work support, but they are often swept up in anti-trafficking efforts. Butterfly members have been charged with third-party sex work offenses for merely assisting with client communication, scheduling, advertising, and screening. While the punishments for a third-party sex work conviction are already severe, third parties convicted of human trafficking are subject to a 4-year mandatory minimum sentence, which could result in the removal of status and deportation for those who are not Canadian citizens. If you truly wish to support people at risk of exploitation and abuse, you must listen to sex workers and reject Bill S224 in its entirety, fully decriminalize sex work by removing all sex work-specific criminal offenses, remove immigration regulations that prohibit migrants from working in sex work, stop surveillance, raids, detention, and deportations of sex workers, support non-carceral forms of safety, such as decent work, healthcare and housing for all, and investing in grassroots communities so they can support each other. Thank you.
Thank you. I want to thank both of you, Ms. Lam and Ms. Kalanchu. Next, we'll go to our first round of questions for 6 minutes. And for those witnesses, I just want to let you know I do use cue cards. So when you're 30 seconds left in the time, I'll put that up. And when you're out of time, I'll put that up so that the out of time red card, just so you can wrap it up and I don't have to cut you off. So we'll begin with Mr. Moore for 6 minutes.
Well, thank you, Mr. Chair, and thank you to our witnesses, a great panel of witnesses on this important bill, and also want to thank you for coming back to the committee because we know our schedule being what it was and with votes and so on, we ended up having to move your testimony a couple times. So really important that we heard from you, and I'm glad that we did because your testimony was very helpful. Dr. Benedett, you appeared in the Senate committee study on this bill last June. You said that removing the requirement to prove a reasonable apprehension of fear would be helpful in part because of the use of the reasonableness standard tends to allow stereotypes and myths about trafficking to enter the picture. Doctor, can you elaborate on that specific point?
Sure. Well, anytime you put an objective standard into a criminal offense like that, you need some kind of a benchmark against which to measure reasonableness. And I think generally speaking, in the modern context, we recognize that it is inappropriate for the reasonableness of victims' fear to be judged by third parties. And so in the context of trafficking specifically, you have the reality. These convictions are very hard to obtain because sometimes the coercive behavior, the fear, isn't explicit and it's not overt. There's so much manipulation going on behind the scenes, or sometimes quite overtly, as you've seen from Ms. Wood, that it's difficult then to say, well, in reasonable, a reasonable person would fear for their safety under those conditions. And we know the history of that because we used to have that in sexual assault law. It used to be that if you submitted to sexual activity out of fear, the courts would judge whether your fear was reasonable, right? And it was an invitation to myth and stereotype, and in particular to judges saying, well, you could have done this, you could have done that, you had other alternatives, the door wasn't locked, you could have gone back to your family, And so in the context of human trafficking, the same thing happens. He didn't take your cell phone, you were still in contact with your mom. And so, how can it be said that you reasonably feared for your safety? So it's an inappropriate requirement. It's inappropriate in criminal harassment, where it remains as well. And so we have a lot of evidence of that in connection with other offenses, and we have evidence of that in the human trafficking offense. And it's part of the reason convictions are so difficult to obtain.
Thank you for that. It's very helpful. Ms. Wood, according to the Canadian Centre for Justice and Community Safety Statistics, human trafficking, they reviewed it for over a decade, and they found that the vast majority of detected victims of human trafficking were women and girls. That was 96%. And 1 in 4 of the victims was under the age of 18. You had a great quote. You said, ensuring we have a justice system, not just a legal system. I think that's something we should all aspire to, that victims feel that there's been justice done, not that they're within the giant wheels of a legal system that doesn't value them and doesn't prioritize justice. And that's what we're certainly working towards here. The work that you're doing with young students, Brave Education, can you expand on that a bit? Because that jumps off the page to me, about 1 in 4 victims being under 18. Your presentation was very well, but I'm interested in hearing a bit more of that work.
Yes, absolutely. Thank you so much. To add to those statistics as well, I want to add that roughly 51% of all human trafficking victims are Indigenous women and girls in Canada. And although we don't necessarily have stark statistics on boys and men because they're not overly mentioned, it's estimated that up to 25% of victims of human trafficking are boys and men as well. And so that is an area of research that Brave Education is pursuing with the help of Ana Lucia as well. We work in human trafficking prevention education. We work in empowerment. We work in making sure that everything is culturally relevant, culturally inclined. We work with communities across Canada, far and wide, every province, every territory, every community, to understand what our youth are seeing in terms of what might be deemed human trafficking, in terms of exploitation, especially with regards to technology, especially with regards to this manipulation, this grooming, this recruitment that we see in situations of human trafficking. We do community consultation across Canada to build education, to understand and to change things in our curriculums to suit those communities, to suit the ever-changing crime of human trafficking. And what we see on the ground in those classrooms is absolutely horrific. There are young women and girls that go missing, especially in Indigenous communities, who are suspected to have been trafficked, many of which are from the inquiry into missing and murdered Indigenous women and girls in Canada. I cannot say enough. What we see on the ground with education is always changing. And so our curriculum tries to stay as up to date as possible as things change and as we learn new things every day.
I think I'm just about out of time, so thank you.
Thank you, Mr. Moore. Next, we'll go to Ms. Briard for 6 minutes.
Thank you, Mr. Chair. I'll ask my question to Dr. Bernadette. You wrote in your 2018 submission to this committee that, and I quote, defining exploitation in terms of threat to physical safety is unduly narrow and makes the offense extremely difficult to prove. Could you please expand on that in link with this bill?
Sure. Thank you for the question. It's as I said in my introductory remarks, I think there is a reason why the definition of exploitation in the Palermo Protocol refers to the exploitation of a condition of vulnerability. And indeed, the other offense we have in the criminal code that is drafted in terms of exploitation, sexual exploitation of a young person, Section 153, had to be expanded because this idea of limiting it to a relationship of trust, power, or authority was simply too narrow. And so we added to that offense a relationship of dependency and a relationship that is exploitative of the young person. Trust, power, and authority can sometimes be interpreted quite narrowly by the courts. They're sometimes looking for kind of formal relationships of authority. And often what's happening, particularly with young victims, is that what you really have is the exploitation of a condition of vulnerability. So I mentioned, for example, women and teenage girls with intellectual disabilities, which is an area I've done some work in over the years. And in many cases, it actually doesn't take a lot of threats or violence or coercion to lure those women and girls into the sex trade. And so what you have then is traffickers selecting their victims based on their vulnerability and based on their marginalization. They don't always need to use violence because they're choosing victims that they can recruit into the sex trade and keep there through other forms of manipulation. And so I think it's important to recognize that, and that the selection of the victim, the fact that there are so many young people, the fact that there are so many Indigenous women and girls, is a reflection of the vulnerability of the victims and the fact that you don't always need to use threats or violence to lure someone into a trafficking situation.
Merci. I'll switch in French. Est-ce que alors vous...
So, do you believe that the fact of getting rid of the notion of threat to one's safety and expanding the definition of exploitation, by doing that, would Bill S-224 reinforce the perception that sex work is a form of exploitation?
Well, just to be clear, as I said at the beginning, this only applies where there's a third party involved. So prostitution, the commercial sex trade, can be very exploitative even without a third party involved. Many of the circumstances that drive people into prostitution are all the hallmarks of exploitation. But what we have here is a situation where you have to prove that the individual knowingly and intentionally did one of a number of listed acts that caused another person to enter into or to remain in the sex trade. So there's already a considerable amount of actus reus or mens rea before we even get to the question of whether the circumstances of those acts are exploitative. And now the proposed definition in Bill S-224 says, well, it is a situation in which you cause that person to provide or offer to provide labor or a service, and you do so with the use or threatened use of force, another form of coercion, deception, fraud, the abuse of a position of trust, power, authority, or any other similar act. So I think it's important to understand what we're talking about here and what has to be proven. This is still not going to be an easy offense to prove, but it's one that will be simpler and more straightforward and involves less judgment of whether victims feared for their safety and indeed whether those fears were reasonable.
Ms. Wood, you have your hand up. Is it a point of order, or do you want to add to that question?
If I just may add in support of that.
Okay, I'll let Ms. Briard decide if she wants you to
Yes,
continue
it's
that.
it's okay, Mr. Speaker.
Okay, thank you.
Thank you. I just want to reinforce what she was just saying. In some research actually conducted by sex workers, Christine Bruckert, specifically Dr. Bruckert, she's a PhD at U Ottawa, she stated in her work that the majority of sex workers work independently, and estimated between 80 to 90% of sex workers in the sex industry in Canada work independently. They do not have someone telling them what to do or how much to make. They make independent decisions without the threat of force behind it. Trafficking victims are not as lucky. They're under the control of their trafficker. And victims of trafficking know that there's often a physical and emotional price to pay if they don't bring home enough money. Again, driving home the fact that in trafficking, there's also that third party controlling the actions of an individual, where in the instance of sex work, the worker in question has the control and the fully informed choice when to start, when to end, who to engage in sexual activity with. Trafficking victims are not that lucky.
And I think we're out of time, Ms. Briard. Next, we'll go to Monsieur Fortin for 6 minutes.
Oui, bonjour, monsieur.
Hello, Mr. Chair. This is Yves Perron replacing Mr. Fortin. So, hello, everyone, and I'd like to thank our witnesses for being with us today, and thank you for your specific testimony. Mr. Benedict, in the 4 points you mentioned, you were referring to multiple issues, and you did a very good job explaining your arguments, of course. And there, when we look at it, there's about 12% conviction charge, so it's very hard to prove. And something that I found interesting was that what else can we do? What more should be done, and what should be modified in the bill as it is proposed to maybe remedy some of the issues you've raised?
Well, thank you very much for the question, and I'll just say that I appreciate very much the work that Ms. Wood is doing. I certainly don't agree with her analysis that 80 to 90% of the sex trade involves people who are not exploited. Whether a third party is involved or not, there's still a considerable amount of exploitation that typically pushes people into prostitution. That's the reason why we have such an overrepresentation of Indigenous women and girls in the sex trade. But in direct answer to your question, which is what else can we do? Well, here I would encourage the committee to look at some of the initiatives that have been, brought forward by member states in Europe, and in particular the Organization for Security and Cooperation in Europe, the OSCE, has a bureau to combat trafficking in persons. It does a lot of really excellent monitoring. I would say that of all the member states, France is the country that is by far, gone the furthest with this. But it's really about bringing our domestic laws into line with our international obligations. We have an international obligation to punish human trafficking, and we have a definition internationally that speaks about the exploitation of a condition of vulnerability. And so my worry with S224, it's an improvement, certainly, but my worry is that we've just moved the focus on coercion and physical force and fear and threats into the definition of exploitation. We've got rid of the reasonableness requirement. That's a step in the right direction. But the question will be, well, how do the courts interpret any other similar act? Are they going to recognize threats to report you for welfare fraud? Are they going to recognize threats to disclose pornographic photographs to your family members? Are those going to be seen as forms of coercion? Are they going to recognize that kind of emotional manipulation? We had a notorious trafficker in Vancouver who bought a small dog, and if the girls were good, they got to take the dog for walks. And if they were bad, he would abuse or threaten to abuse the dog. So these are all very effective techniques for keeping women in line. And so we just have to make sure that we're not narrowing the definition in a way that's artificial. And to me, the way to do that is to look to our international commitments.
Merci beaucoup.
Thank you very much, Ms. Benedict. Unfortunately, I have very limited time. But you also said that the committee should look into what the European states have put together. I unfortunately will not have time to go into depth on this with you, but if you could submit to the committee in writing a couple of recommendations that you think are relevant, that would enrich our work. If you could do that in writing, we would really appreciate that. And before I run out of time, if you want to go ahead and clarify what you said about the Palermo Protocol and the criminal code, which are not overlapping, could you quickly clarify what you meant by that point and what needs to be modified in our bill so that there is more of an overlap?
So the Palermo Protocol, when it lists the ways in which people can be exploited by traffickers, mentions many of the things that are in this bill: force and coercion and deception and fraud. But it also speaks about the exploitation of a position of vulnerability. That's the language that's in the Palermo Protocol. And I'm just pointing out that that doesn't appear anywhere in Canada's human trafficking laws. And it's useful, and particularly useful for minor victims of trafficking, where sometimes the grooming and the manipulation means that you won't see force, coercion, deception, fraud. And we're going to have to rely on the courts to say, well, the trafficker is in a position of trust or authority merely because he's an adult. And that's not what we've seen in the exploitation offense in Section 153.
Je m'excuse de vous couper, madame.
I apologize to cut you off, but before I run out of time, so you are clearly recommending that this should be brought into the bill through an amendment, the notion of the exploitation of a condition of vulnerability. Am I getting this right?
That's right.
Merci beaucoup.
Thank you very much.
Thank you. Next, we'll go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. I want to take a step back from the details of the bill, and I want to ask Sandra Cahonchan and Elaine Lamb a question. The bill seems to presume that while we all know there's a problem with trafficking, the solution is to get more convictions. And I think in your brief that was circulated to the committee, you made some suggestions about what might be more effective in reducing trafficking than focusing on convictions.
Yes, thank you, Mr. Garrison, for that. I'll take that first, Elaine, and I'll pass it over to you. We mentioned in particular the decriminalization of sex work because we do think that this bill does equate sex work with sexual exploitation, and decriminalizing sex work, when you actually do that, you would allow people who are experiencing abuse and exploitation within sex work to have the benefits of labor and employment legislation, occupational health and safety legislation, all the things that other people within non-criminalized sectors have access to. I also wanted to just make a quick point about the Palermo Protocol because that was such a big point that was discussed in the previous speaker. The UN itself has criticized this pre-existing vulnerability condition as being so broad and vague that it will capture anything, including irregular immigration status, capturing people who are managers, supervisors, and transporters who provide supportive services to sex workers. So I would caution against expanding that notion because we already have the current definition of human trafficking does not require a threat to physical safety. It already includes threats to psychological safety. You do not require a complainant to testify already. It is interpreted so broadly as it currently stands that expanding it to include this will be capturing far more people. That Elaine, I'll turn it over to Elaine, that she's already shared the experience of Butterfly, but the UN itself has criticized expanding this notion.
Yeah, I think that when we talk about this issue, we need to be clear what we are going to do here. Are we going to end exploitation, end trafficking, or are we going to end sex work? And I think this is need to clear because I keep hearing the conflation that actually give a lot of misinformation that the goal is ending exploitation, is not ending sex work. But a lot of recommendation of ending sex work actually create the vulnerability, is create more opportunity of the exploitation of the community, particularly Asian migrant sex worker, racialized sex worker. And when we think about the solution, we need to think about what make the people have the power. We talk a lot of the, why there is the exploitation because of the power dynamic, power control. Many of the recommendations giving more policing in people's life, more like criminal law actually make the people more difficult to protect themselves to access the power. And many recommendations of Sandra suggest actually give the power to the individual. When I hear that they assume people do not make the decision of their life, they don't know about themselves, this is extremely violent because take away the agency of people, particularly sex workers. No matter how old is the sex worker, there is certain way of agency people exercising. Instead of impose the moralistic agenda, sex work is bad, you should not do it. We need to recognize and understand the complexity of the relationship, and giving the power resources, people can make the decision of their life, like what we have done with domestic violence. We will not have the police to go to arrest the husband. They say, you don't know your husband is abusive. You may find it out 5 years later and arrest your husband. But why we do with sex worker, right? Instead, we let the people know what is the power within the marital relationship, that what you can have different kind of support, that you can make yourself safe. If you want to leave this relationship, what kind of support do you have? Similar to sex workers. So assuming all the third party is dangerous, is violence, is trafficker, is extremely ridiculous, because we have workers do not have credit card. Their husband used the credit card to pay for the bill and being charged. So that is the law, what happened now. And now they are not only being charged by sex worker law, they will be charged by the trafficking law, and potentially they put in 40 years in prison. And when you see the picture of trafficker, who are trafficker, young Black men. And when you see the statistics who are being charged by the third-party law, many of them are youth themselves. They help other people. Are we going to see more of our community, sex worker, more community, racialized people put in prison? Is it something as the solution? It's not. What we have here, a lot of recommendation is not going to end trafficking. It's not going to end exploitation. They will just make the sex worker, people in sex industry, be more vulnerable, more stigmatized, more marginalized. So that's why when we ask about solution, how we can give the power of people hand, the people can have the agency. They can tell you what they want, what they need, instead of you assume that they are no brain, that they don't know that they are being trafficked. That how we can support the people, build the capacity, they know the agency, they can have better decision option about their life, instead of you put your moralistic agenda in our life. So this is what sex workers keep saying, that sex workers should have the right to decide whether they want to continue the work or stop the work, but it is their own say. Thank you.
Hard to see
I just want to remind you still have 30 seconds, Mr. Gresham. I just want to remind that speak a little slower for our interpreters, to all the witnesses. Continue, Mr. Garrison.
I'm not sure what I can do with 30 seconds of question here, but I want to emphasize this idea that expanding the net and catching more people who may not be actually involved in exploiting is a side danger, I think, that you're bringing our attention to of this bill, that we will end up causing prosecutions of people who aren't actually in relations of exploitation. Maybe just quickly, Ms. Kahunchu.
Can I just make I know I've talked to many sex workers and third parties who they're being double charged with sex work and human trafficking offenses. And I think it's really problematic to suggest that the low conviction rates are because it's really hard to prove human trafficking. It's because police and prosecutors are charging people and expecting people to plead to the charge of sex work offenses. And we see that consistently in so many cases that these charges are eventually withdrawn because people will plead to a sex work offense. So I think you need to reconsider that the idea that it's very hard to prove, it's actually because of police and prosecutorial practice.
Thank you. Thank you, Mr. Garrison. We'll next go to our next round. We'll do these in 4 minutes. So we'll begin with Mr. Van Popta for 4 minutes.
I think it's you. Mr. Chair?
Yes.
It's actually my time.
Oh, Mr. Brock. Okay, sure. We'll go to you. I was told that it's going to be Mr. Van Popta, but you can.
Yeah. With time permitting, I may share my time with Mr. Van Popta. So I just want to just clarify a couple of points. To firstly, thank you, ladies, for your attendance, your long-awaited attendance to speak on this important issue. I just want to push back a little bit with the utmost respect to Ms. Chu and Ms. Lam. I come from a legal background. I was a prosecutor for almost 18 years. In fact, in my office in Brantford, Ontario, about an hour west of Toronto, I was the designated human trafficking crown. And I can tell you with, and perhaps my experience differs from other prosecutors across this country, but I can tell you my experience that Ms. Lam and Ms. Chu have described in terms of prosecutors simply looking for an easy way out and, in fact, exacerbating the problem with respect to prostitution has never been my experience. Trafficking, human trafficking, inherently with the tools that we have in the criminal code and the vulnerability of the victim himself or herself makes prosecutions very, very difficult. So when we have bills as legislators that give prosecutors some tools to assist us in aiding in the prosecution of holding these offenders accountable and sentencing them accordingly, in my view, is the appropriate thing to do as legislators. So, and I say that with respect because perhaps my experience and my police service experience differs from the experiences shared by Ms. Lam and Ms. Chu. But to Hollywood and to the professor, I have access to a document that was a submission made by the HIV Legal Network and the Butterfly Association, both organizations that Ms. Lam and Ms. Chu belong to. And I want to read out a passage, and I'd like to get your observations and thoughts on it. They state as follows, that Canada's human trafficking laws have a long history of effectively being anti-sex work laws. Today, prosecutors, police, and policymakers continue to primarily understand human trafficking as sex trafficking, and sex work is often seen as trafficking regardless of circumstances. So starting with perhaps Hollywood, your thoughts, please, on that passage.
Yeah, absolutely. Just kind of bouncing off our ongoing conversation here, I think that we do have a lot of social, legal, and political biases with regards to sex work and sex trafficking. They are often conflated, I will say that. However, I think you made a great point of saying when you are prosecuting the crime of human trafficking, there is a high legal threshold. You have to have victim participation. You have to meet these evidentiary burdens. And in my work with police officers, if they walk into a suspected human trafficking situation, and these are police not only from Ontario, BC, Manitoba, etc., if they walk in to a call where suspected human trafficking is happening, actually this happened in my hometown about a month ago, a 14-year-old girl was suspected to be trafficked in a hotel room, and the police officer walked in to investigate, and the girl said, "Oh, no, it's just my boyfriend. We're just in a relationship and we're just inviting additional people over." So police have to leave. They do have to, again, like you're talking about legal threshold where police look at a situation and say, okay, well, is there fear? This girl seems to be perfectly consenting regardless of the fact that she's a youth. They have to leave that situation. They have to leave piles of files on their desk because of the current high legal threshold with regards to our current criminal code provisions regarding human trafficking. But I will let Professor Benedict take it from here.
Thank you. Unfortunately, I don't think I have any time for Dr. Benedict to provide her observations on that, so I apologize to you, Doctor, and I apologize to my colleague, Mr. Van Popta, for not giving him any time to ask a question. Thank you.
Thank you, Mr. Brock. We'll now go to Ms. Diab for 4 minutes.
Thank you, Mr. Chair. Welcome to our witnesses. Let me ask a question to Ms. Sandra. Looking at it from the direction that you are and the workers that from your experience with the Asian and migrant sex workers, obviously it's a racialized but also very vulnerable communities across the country. Can you tell me your experience? And you had started to talk about policing and prosecutorial practices, and so what recommendations would you have that you would like to see done with respect to this bill? Just one last time.
Thank you. I would like to, as we submit in our joint submission, to reject the bill in its entirety. There actually was a subjective requirement under the human trafficking requirement in 2012 that was changed to this reasonable person standard because of the notion that it was too hard to convict, requiring complainant's testimony. You do not, I can't emphasize enough, you do not require complainant's testimony under this current version of the law. Reject Bill S224 in its entirety. You need to support, as Elaine said, non-carceral forms of safety. People do not require more policing. We've poured hundreds of millions of dollars into human trafficking initiatives and allowed more police and prosecutors to flourish in this anti-human trafficking world, but that hasn't translated to more safety. And we care about safety of migrant workers and people who are experiencing exploitation and abuse, but you need to support them to obtain decent housing, access to income supports, access to childcare, access to housing, all the things that I'm sure the other witnesses will agree that are helpful in terms of supporting people. I want to also provide my time to Elaine to share more of the experiences of Butterfly, their firsthand experiences of policing in the context of human trafficking.
Yeah, and I think that like what Butterfly have been doing is building the community support that to help the community member to deal with any kind of issue they are facing, including the workplace exploitation or including the intimate violence, that we will work with the community member. What do they want, right? So that whether they want to leave the partner or they want to have like protect themselves, how to negotiate, so that or whether they want to change the working environment, and centering the voice and agency of the workers is very important, and particularly because this is some community support that people know each other, like the conditions very well. And so that we also work with different service provider. And also, as Sandra said, that having the structural, systematic support, income support, housing status is also very important for people.
So Ms. Lam, what is your fear with this bill then, with regards to
this bill is because what we see already, sex worker, they help other people to do advertisement, or their family member, they help them to communicate, already being charged by the sex work related law. So with this, they are not only charged by sex worker law, they will also charged by the trafficking law. They are facing 14 years in prison. And so this is the law not only covers sex worker, any kind of racialized people. We see how racial profiling now is happening, that when prosecutor and police have so much power, they can use whatever way to interpret different kind of, because by this law, not only people work in sex industry, even in other intimate partner relationship, they may also can charge as trafficker, and also any kind of working relationship. And we see that racialized people is being targeted, but we see police already target sex work. This will become a powerful tool for the police to harass the sex worker and charge the sex worker, even no one want them to be in their life. No trafficking, no exploitation is going on, that they actually make them be more vulnerable because their workplace being raided, they're being place being shut down. Yeah, thank you.
Okay. Thank you, Ms. Diab. We'll next go to two 2.5-minute rounds, beginning with Monsieur Perron for 2.5 minutes.
Merci beaucoup.
Thank you, Mr. Chair. I'll try to go quickly. Ms. Wood, a brief answer, please. You were referring to people being completely independent in this field of work in this area. What would you say would be the ratio of people who are victims of human trafficking as opposed to people who are consenting?
That research has not necessarily been done. I think when it does come down to independence, we have to remember the Bedford case, which allows sex workers to hire drivers, security guards, and individuals to make sure that they do make it home safe at the end of the day. And it would be my hope that with proper judicial training, a judge would be able to differentiate, but I don't think those statistics necessarily exist.
Merci beaucoup.
Thank you very much. Ms. Kahonchu, Ms. Lam, I don't know which one of you would like to answer. What would you say the ratio would be? Because you seem to be thinking that there are people who are consenting, but others maybe not.
Go ahead, Elaine.
I think this is the question you asked: how many people in marital relationship they feel forced, and like the relationship they feel they are in vulnerable situation. I think this is very, very difficult, that because this is a power dynamic. So I think what our focus is see that how our intervention actually support the people. They can have more power, resources, then they can negotiate better condition, no matter in intimate relationship or in their workplace. That's why the income support, like social support, and particularly from the community, is very important way to make the people, because we see so many misinformation.
Merci beaucoup, Madame.
Thank you very much, and I apologize for cutting you off because I only have 30 seconds left. So it's not easy to answer this question. That's why I wanted to go in this direction. So the objective of the bill is to protect people who are in a vulnerable situation, and there was a suggestion to introduce the notion of the exploitation of a condition of vulnerability rather than rejecting the bill in its entirety. Do you not think that we can introduce this notion and improve things overall?
Is that a question for the two of us?
Oui, oui.
Yes.
I would say that no, I don't think it would improve capturing exploitation. If improving capturing exploitation would mean allowing people in the sex industry to have access to labor rights, employment rights, occupational health and safety rights. You're just muddying the waters right now if you add that condition.
Thank you. Last to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. Again, to Elaine and Sandra, sorry, I have trouble being formal with people I know. Is it fair to say that your argument in your brief is that if we actually decriminalized all the aspects of sex work which remain criminalized in this country, we would actually reduce trafficking and the dangers of trafficking?
Yes, definitely. When we work with the community, so that fear of the police, law enforcement is the major source of create the unsafe working condition, create the vulnerability of the worker, take away the criminal law, including sex worker, client, and third party, that they can have the support system, they can work safely is very important. And the other, of course, like status support or income support is also other kind of very important measure to make the people can have safe and working conditions. So, and take away the criminal law, full decriminalization of sex work, and do not assume the third party is exploitation and trafficker. I think this is also very important. Yeah.
Can I just jump in quickly to say the experience in New Zealand is instructive because they have decriminalized in 2003, and sex workers there have access to labor tribunals, human rights tribunals, all the protections that other people in other legal decriminalized sectors have access to, and they have brought people who've exploited them and abused them to those tribunals to fight for their rights. And I think that is an instructive example.
Is that it, Mr. Garrison? Sorry, I can't see you from here.
Yes, Mr. Chair, I believe the time has expired.
Thank you, Mr. Garrison. I want to thank all the witnesses for your very valuable testimony and appreciate you coming. And once again, apologize for canceling the last time. And this was a pretty fulfilling meeting. I think everybody got their questions and wholesome answers out of them. So thank you. I just have one committee business for all the members. I believe it was to pass the budget for the study on S225. Everyone okay with that? I don't see any nods. All good?
Yes.
Perfect. Thank you. And that's it. We will adjourn and I'll see you on Wednesday. Thank you.
Thank you.